27, my lord. I am appearing for respondent number 2, received copy today, my lord.
Learned Counsel Sharad Dodwad seeks 2 weeks' time to file statement of objections, if any, or make submissions. List the matter on 26th. I vote till then. Yes. Heard Kirtana Nagar. Yes, next.
28.
Lords, I am for petitioner, Lords.
26th.
Yes,
List on 26th. Interim order subsisting shall continue till the next date of hearing.
Obliged, Lords.
In this case, the respondent, my lord, court notice agli sume. Copy receive agide, ನಮ್ಮ ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗ್ತಿಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್.
ನಿಮ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಬೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಸಿಗ್ತಾರೆ.
My lord's trial is fixed tomorrow itself.
Tomorrow.
Tomorrow. The
We'll keep
witness
the
summons,
petitioner present tomorrow. Complainant or health. Yes, what happened, man?
the trial is fixed tomorrow. Witness
Trial
summons
fixed tomorrow.
has been issued. It would render a petition infructuous, your lordship. The offense is 3-1R, my
I am
lords.
aware, madam. ಧಾರವಾಡದಲ್ಲಿ ನಾನೇ ಮಾಡಿದ್ದು first.
227
ಇದು
rejection.
cancellation of bail da ಇದು.
ಅಲ್ಲ,
No,
227. They come and discharge.
rejection.
Discharge.
Yes.
No grounds to discharge at all.
3-1R does not attract, my lords, because the entire case, it is completely, there is political vendetta involved in this.
Aware, yes.
Even find out for once if we agree also, but 3-1R, he's merely stating it was not with an intention to humiliate because he belonged to the SCS. There's a para in the complaint, if I may be permitted to read, your
Please.
lordship.
Yes.
At page 106, the complaint copy.
This is that flex problem.
Flex,
Yes.
it arises, prior to that also, there were newspaper publications published by the complainant against the petitioner.
ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
Plus,
ಯಾಕೆ?
senior.
Yes. We'll post it on 26th.
That,
1 minute. List the matter. Heard the learned counsel appearing for the petitioner. The learned counsel for the petitioner would seek to contend that the offense punishable under section 3-1R or S would not become applicable in the case at hand. The learned counsel for the respondent seeks time on the score that the arguing counsel - the senior counsel is not available today. List the matter on 26th. Till such time, the concerned court shall defer its proceedings.
3-1R only, my lords, not 3-1S is not
We'll
touched.
decide. Yes. Next.
40.
I appear for petitioner. Lords, this is one of those iron ore mining export matters.
ಇದು BS Prasad ಎಲ್ಲಿ? All these matters are the same.
Lords, my lords was the vendor to the, both are the same.
Stay ಇದೆಯಲ್ಲ?
Stay.
Yes. Again, madam, 26th. Madam, 26th ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಜಾಸ್ತಿ ನಾವು. Right. 26th, list on 26th. Awaiting the appearance of counsel Shri BS Prasad. Interim order subsisting shall continue to the next date of hearing. Next,
30 and 30.1 minutes.
both. Yes.
Please, oblige.
31.
ಎಲ್ಲ all revision petition will hear on 26th.
Kindly secure the records, send back the, kindly directly register it to secure the
Yes,
records.
so SCR sent to sessions court. Why?
We filed application for withdrawal of amount, that's why trial court records,
You have withdrawn the amount?
no, lord. Bank guarantee order ಮಾಡಿದ್ರು, 2 lakhs something,
The
bank
registry is directed to secure the concerned court records by the next date of hearing. List on 26th.
much please.
Yes, next.
30. 32.
ಏನಿದು?
CD.
ನಿಮ್ಗೆಲ್ಲ CD ಇಲ್ಲ ಪೆನ್ ಡ್ರೈವ್. Yes,
26.
ಅವತ್ತೆ ಕೇಳೋಣ. 26th, list on 26th. Interim order ಇದೆಯಾ? Subsisting shall continue till the next date of hearing. Yes, Balakrishnan sir.
I appear for the petition.
Ah.
Since charge sheet is filed, this may be dismissed as not pressed.
Yes, madam. On the chat. Yes,
Please,
Liberty, yes. Further hearing,
Further hearing 34.
ನನ್ ಮುಂದೆ ಐತಾ further hearing?
My lords, I appear for the petition.
Ah.
My request for 26th, my lords.
List on 26th at the request of the counsel for the petitioner.
The interim order.
Interim order subsisting We'll continue to the next date. So. Okay, 26, next.
B group at 230, 35.
Appearing for the petitioner, my lord.
Hello, one development says, Professor Ravi appointed as a special public prosecutor in this case.
ಯಾರು?
Professor Ravi Kumar, senior counsel.
ಸರಿ.
Date accommodate ಮಾಡ್ಬೋದು. Just I have briefed the matters.
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು?
After 12th, any date.
19ಕ್ಕೆ ತಗೋಣ.
ಆಯ್ತು.
19.
Learned, yes, sir. The learned counsel, ನಮ್ಮ ಹೆಸರು sir.
Ashok Naik, special people.
Ashok Nayak.
Yes, any.
Learned counsel Ashok Naik submits that counsel, learned senior counsel, Professor Ravi Kumar has been appointed as the special public prosecutor in the case at hand in terms of an order dated.
Dated 3/9/2024.
In terms of an order of the state government dated 3/9/2024, the learned counsel would submit that the senior counsel would be briefed if 10 days time is granted at the request of the counsel for the respondent Ashok Naik. List this matter on 19th. 19th, interim order subsisting shall continue, interim order / protection shall continue till the next date of hearing.
The connected matters as well.
ಎರಡು ಒಂದೇ.
ಎರಡು.
ಮೂರು ಇದೆಯಲ್ಲ?
ಮೂರಿದೆ. ಎರಡನೇದು
ನಾಯಕ್ ಅವರೇ,
Yes,
ಮೂರಲ್ಲೂ ಸೇಮ್
All
ಮಾಡ್ರ?
the three, yeah.
ಸೇಮ್ ಮಾಡ್ರ.
List number 3, fresh matter, still number 1.
ಪ್ರದೀಪ್ 50% ಮಾಡಿದೀರಾ? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಯಾಕೆ ಹಾಕಿಲ್ಲ?
Already filed, my lord.
While learned counsel for the petitioner submits needful has been done. Office to verify, list the matter after 4 weeks, interim order subsisting shall continue till the next date of hearing. Next.
Petitioner, my lord.
List after 4 weeks, interim order subsisting shall continue till the next date of hearing.
3.
Jagdish Aure, inform the Advocate General that I'll take up the matter immediately after completion of this list, even if it's 3:15 or whatever, yes. List after 4 weeks, interim order subsisting shall continue to the next date of hearing.
ಬೇರೆ ಹಳೆವೆಲ್ಲ stop ಮಾಡ್ತಿದ್ದಾರೆ.
4.
These are two
Mediation is on
applications.
11th. Mediation, second session is on 11th.
11th.
ಕೃಷ್ಣ ತಗೋತೀನಿ ಅಂತ ಹೇಳಿ ಇಂಪ್ರೂವ್ ಮಾಡಿ ಇನ್ನಲ್ಲ.
Client is not agreeable for mediation.
ಇವತ್ತಿಂದ ಯಾವ್ದೋ ಇದಾವ 5-6 ಮುಗಿದ ತಕ್ಷಣ ಮೇಡ್ ತಗೋತೀನಿ.
Mediation might not happen, my lord, because
May not happen.
ಇಲ್ಲ. Possibility.
Be positive, sir.
Being positive, my lord, we tried our level best, but there are two applications. One is 311 and seeking for video conference overseas. These are the two applications which came to be rejected.
Settlement ಆಗುತ್ತಾ ಇಲ್ವಾ?
Possibility is there, my lords.
11th ಇದೆಯಾ?
11th ಗಿದೆ.
List on 12th in the fresh matters list.
Please.
Yes.
Apply.
ಅವತ್ತು ಆಗಿಲ್ಲ ಅಂದ್ರೆ will pass orders.
Please.
Yes.
Apply.
Interim order to.
Interim order subsisting shall continue to the next date of hearing.
5.
Copy is out to the lower court advocate.
One issue.
PF ಕಟ್ಟಿಲ್ವಾ?
Paid. It's paid.
Counsel for the petitioner submits needful has been done. Office to verify, interim order subsisting shall continue till the next date of hearing, till the appearance of the petitioner, respondent. Next. Post immediately after service of notice upon the respondent. ಇದೆಯಲ್ಲ ಬಂದಿದ್ದಾರೆ, yes. Why is this awaiting service?
My lord, sir.
Huh?
Respondents,
ಅಲ್ಲ ರವಿ ಕಿರಣ್ ಅಂತ ಯಾರೋ ಇದಾರಲ್ಲ?
yes, my lord, sir, entered the appearance. My lord, sir, I have deposited the 50% before the family court.
Learned counsel for the petitioners of one ನಿಮಿಷ. This court on 9/8/2024 had passed the following order. The learned counsel, ಎಲ್ಲಿದೆ acknowledgement?
I have filed the acknowledgement on 29.
Learned counsel for the petitioner submits in terms of the order, 50% of the amount of arrears has been deposited before the concerned court. The submission is placed on record. Interim order granted earlier stands extended till the next date of hearing. Will permit the wife to withdraw the amount. Last I'll ಬರ್ಕೊಂಬಿಡಿ before that. The respondent wife is at liberty to withdraw the amount of 50% that is deposited pursuant to the direction dated 9/8/2024. On a necessary application being filed, the registry shall transmit the amount in deposit to the account of the respondent wife.
I had deposited before the family court.
Family court.
Please.
ಅದೆಲ್ಲ ಹೊಡ್ದಾಕ್ಬಿಡಿ. The respondent wife is at liberty to withdraw the amount that is said to be deposited before the family court in accordance with law. Yes. Next.
7.
Respondent, my lords. I filed wakalat. I need 1 week time to file.
Learned
objective.
counsel for the respondent seeks 2 weeks time to file statement of objections, comma, if any interim order subsisting shall continue.
ಇಲ್ಲ ಇದೆ.
Continue till the next date of hearing.
Date may
Next.
be, my lords, 26th. 26th.
ಅದೇ ನಿಮ್ ಡೇಟು
ಅಲ್ಲ 20 ಯಾವ್ದು ಎನಿ ಡೇಟ್.
ಮುಹೂರ್ತ ಚೆನ್ನಾಗಿದೆ.
ಅಲ್ಲ ಹಾಗೆ
ಇಲ್ಲ.
ಎನಿ ಡೇಟ್.
All right, list on 25th.
ಆಯ್ತು.
Next.
Number 8.
For the petitioner, my lord. The election 170.
List after 4 weeks interim order subsisting shall continue till the next date of hearing. Next. Interim order ಇದೆಯಾ?
ಇಲ್ಲ. The student, a lot of age 19 years. Sole allegation is that he was alleged to be having an affair with the victim's wife. And on that score, my lord, he came to be.
You are a
arrested.
student of,
I am a student, my lord, of.
you are 19 years old.
19 years, old, please.
You are alleged to have an affair with whom?
The wife of the victim,
Wife of the?
victim. 306 is your.
Wife of the victim.
Please.
Who's the victim?
But he's no more, he's deceased, 306.
What was
is
the
your-
age?
He
of
was
the victim?
26, my lord. He was. 26 years, please. ma'am.
Death note ಇದೆಯಾ? Yes,
ಇಲ್ಲ.
madam. ಇದೆಯಾ? Papers ಎಲ್ಲಿ madam? ಬಂದಿದೆಯಾ?
We'll secure documents, my lords.
You have secured?
Please, not at my lords, we'll secure the documents.
All right, the learned HCGP is directed to, notice ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ.
Please,
The learned HCGP is directed to secure the papers of investigation and place it before the court on the next date of hearing. Next Wednesday in the fresh matters list.
please.
No? Next, let me see.
10.
This is, my lord, 340 proceedings initiated at the behest of the court.
ಇದರಲ್ಲಿ stay ಇದೆಯಲ್ಲ? List after 2 weeks interim order granted earlier stands extended to the next date of hearing. Next. Shanti Bhushan,
7.
306, my lord, the ingredients of one.
stay ಕೊಟ್ಟಿದ್ದೀಯಾ?
No, my lord, in the similar matter, my lord,
ಅದೇನು similar?
almost similar.
Almost similar.
The allegation is that, my lord, the lordship
I
had,
had directed records. ಯಾರಿಗೆ ಇವ್ರು ಇರ್ಲಿಲ್ಲ ಅವರು ಇನ್ಮೇಲೆ ನೇಮ್ ಹಾಕ್ಬೇಕಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ನ. ಎಸ್ ತೇಜಸ್ ಅಲ್ಲಿ ಇಲ್ವಾ? ಎಸ್ ಗೆಟ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಲರ್ನೆಡ್ HCGP 1 ಡೇಟ್ ಏನಿದೆ ಅರ್ಜೆನ್ಸಿ?
I'm absconding, my lord, his.
ಕಸ್ಟಡಿಲಿ ಇದಾರಾ?
No,
ಇಲ್ಲ ತಾನೆ? List the matter again on Wednesday in the fresh matters list. The learned HCGP is directed to secure the investigation papers.
great.
ಅವತ್ತು ಕೊಡುವ ಆಲ್ಮೋಸ್ಟ್ ಸಿಮಿಲರ್. ಅದಕ್ಕೂ ರಜದ್ದು ಅಷ್ಟೇ ಆಲ್ಮೋಸ್ಟ್ ಸಿಮಿಲರ್, ಅದಕ್ಕೆ ಹಂಗೆ ಕೊಟ್ಟಿದ್ದು. ನೆಕ್ಸ್ಟ್.
Please.
12.
To 12, I represent the petitioner. Twelve, my lords, I represent the petitioner, counsel.
ಫುಡ್ ಏನ್ ಇಲ್ಲ ಆಗಲ್ವಲ್ಲ ಈಗ?
ಅಲ್ಲಲ್ಲ ಆಗಲ್ಲ, but my lord, the only thing is, my lord, I thought I'll assist your lordship to lay down some guidelines for any date convenient next week.
Correct. We'll interpret the
Yes,
provision of
sir.
law and lay down such
Yes,
so that problems would not crop up in future.
yes, yes. I will assist, my lord. I'll place before your lordships all the regulations.
Yes, HCGP. Darshan food. ಬಳ್ಳಾರಿಗೆ ಹೋಗಿದೆ.
No, but it will cause the serve of justice, my lord, if lordships
ಆಯ್ತು, we'll
permit
see,
me
we'll
to
lay
assist.
down.
Please.
Connected. ಏನು?
Submission is that, my lord, but the homemade food should be allowed, my lord. So there is no bar for that. Because the manual also speaks that.
ಹೋಮ್ ಮೇಡ್ ಶುಡ್ ಬಿ ಅಲೌಡ್ ಅಂದ್ರೆ ಅದ್ರ ಜೊತೆಗೆ ಅದು ಇದು ತರ್ತೀರಾ ಅಂತ.
Yes, sir, scanning machine is there. They are on duty, they are with the liberty, they can search.
What search?
Then, from
ಏನ್
last
food
2
ನ
years,
search ಮಾಡಕ್ಕಾಗತ್ತಾ ಹಿಂಗೆ?
5 minutes, that is with the scanning machine. Even though from last 2 years the food is stopped, then also the prohibited items are entering. We have
Entering?
not responded. The visitors and the prison relatives are not responsible for the prohibited items which is entering into the prison. There are
Yes.
so many facilities, there are so many things which should be addressed, my lord. Though no medical, good medical
SPP ಬರ್ಲಿ.
facilities, my lord.
Let the SPP come. I'll give a date and on that day we will pass some order.
Because ನಮ್ಮನೆ ಊಟ ತಿನ್ನೋದಕ್ಕೆ nobody can. They what the,
Sir,
what food
ಒಂದ್
they
ನಿಮಿಷ,
are providing.
ನಿಮ್ಮನೆ ಊಟ ನೀವು ತಿನ್ನೋದಕ್ಕೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಆದ್ರೆ ಜೈಲಲ್ಲಿ ಅಂತ ಪ್ರಾಬ್ಲಮ್ ಅಷ್ಟೇ.
Yes, but it is the, I am covered under Article 21. like
ಅದು we'll see, we'll answer all that.
If they provide me a nutritious food, then
Hmm.
there is no problem.
Correct, we'll see what is their diet and what are they providing, we'll see.
And no, even medical facilities is also not properly given to the prisoners. my lord. So many prisoners are complaining about the painkillers, the root and the
Pain.
normal pain. Yeah, ಎಷ್ಟೋ prisoners ಗೆ ಹೊಟ್ಟೆ ನೋವು, ಇದು kidney
Kidney
problem,
ನೋವು.
hernia problem. Until and unless it is addressed before the court, the CMO and the doctors in the prison hospital.
No, we'll lay down all comprehensive guidelines, wait. Yes, Jagdish?
And another thing, my lords, a 90 years old lady is also, she is not provided good food in the Gulbarga also, the prison, my lords.
Why not provide food?
Necessity of 90 years old lady. my
Why
lord,
is she in custody?
She is convicted for 4 years, my lords. And even if she filed for a parole also, she is not entitled because she has not completed still 7 months. She has completed only 7 months until she has completed 2
ಅದು
years.
ಗುಲ್ಬರ್ಗಾ ಕೋರ್ಟಲ್ಲಿ ನೀವು ಕೇಳಬೇಕು.
This is state problem, my lords.
State problem.
Yes. State prisoners problem, my lords, they are facing. And there should be a guidelines, some education should be given to the prisoners. Instead of wasting the time in the prisons for years together, if compulsory education is given to the prisoners, then then the reformation theory starts, my lords.
ರಿಮಾಂಡ್ ಹೋಮ್ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Easily, my lords.
Yes.
Because there are so many things, guidelines are issued, they should strictly, they have to work and like there are so many laws, my lords, in the.
We'll do something in this.
In
Get
fact, there are various guidelines, my lord, that education is given. People have written degrees, many degrees.
Some
have
people
written
are taking,
not
my
that-
lords, there should be a compulsory education for undertale and convict prisoners, so that there will be a reform, they will reform and come outside.
We'll answer everything. Senior is also there, so we will, in the name of food, we will enter into other things, yes.
Some date which is convenient or whatever.
We'll take it on 11th at 4 PM. List on 11th at 4 PM. ಇದು 63 and this tag ಮಾಡಿ. List on,
Connected but not listed.
ಬಂದಿಲ್ವಾ ಅದು? ನಂಬರ್ ಕೊಡಿ.
13 WP 13.
ನೀವು ಬರ್ಕೊಡಿ. Yes. List on, we'll take it on 11th. Jagdish asked the SPP to come. List on 11th at
Please.
4 PM for further hearing. Orders.
Order 13. 13.
Process 2 weeks.
Process ಆಗಿದೆ, needful done ಮಾಡಿದೀವಿ.
Huh?
Needful done ಆಗಿದೆ ಇವರು.
Needful done ಆಗಿದೆಯಾ? Yes. Counsel for the petition submits needful has been done, office to verify. Entry ಮಾಡು ಉಂಟಾ?
ಹಾ, interview.
Continued. Madam, ಎಲ್ಲಿ ಹೇಳಲ್ಲ, entry ಮಾಡು, continue to the next item. Next. ಇಲ್ವಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಅದೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಇಲ್ಲದೆ ಇರೋದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. Yes. Where's your file, sir?
The highly contested
Where's your
matter.
file, sir?
To come from there is a task, my lord.
Yes.
But there was an urgency from a friend's side. That urgency seems to have been
Electricity
subdued
was
to a certain
disconnected, has
extent.
now been.
Now it is reconnected.
Reconnected.
The urgency is now obviated.
No, that has been.
But my lord, may I
There's
just-
one other aspect, my lords. My gate is locked. I am jumping.
No, my lord, no.
That is because, my lords.
How old are you?
My lords, I'm 51. I'm a lady. I have to jump
Oh.
through my neighbor's house.
No jumping.
No, my lord, let me just make a submission. to the
I'll
record.
watchman
As far
goes
as,
there, I get locked.
as far as the house is concerned, this belongs to senior citizens 85 and 80, my lord. Here, what she has done is, my lord, she's cordoned off the entire ground floor. I don't have access to my own house. And it's come to a situation where a latest FIR, no, five FIRs are registered, my lord. 4 by JP Nagar police station.
My lord,
She has hit the senior citizen with a hammer, my lord.
Huh?
With a hammer, she's hit him.
Who?
The daughter-in-law. She hits him with a hammer, my lord.
Hits whom?
Hits the father-in-law. 85 year
Daughter-in-law hitting father-in-law by hammer.
Man with the hammer, my lord.
There's no such, my lord, no.
I
hammer
have
being used,
videos
no-
to that effect also.
My lord, those FIRs are there, that also, my lord, we are
Why
fighting.
5 FIR?
My lords, the problem is this, my lords. Now, my lords, the in-laws, my lords, they live on the first floor. I live on the ground floor. My lords, I instituted proceedings under the Domestic Violence Act. I had
Okay.
protection orders, my lords.
Yes.
An appeal was filed, my lords, by my husband. My lords, a stay order was obtained.
All right.
I s-
Granted,
Granted, my
not
lords.
obtained. Yes.
Sorry,
Ah.
granted, my lords. I sought for, my lords, modification.
Hmm.
To the extent, my lords, that the protection orders may remain in force. Whatever was the maintenance given, that may be reconsidered, my lords. I had served a copy on my learned friend on 9th, my lords, to have the matter listed on the same day. My lords, I moved the,
Which are those matters? Give me.
Yes.
Give me all the matters.
Please.
We'll
There are
put a
four
quietus
matters,
to all
my lord.
these problems.
482, there's four. My lord, I may just suggest one thing, my lord. Now that the situation is such that they have registered an FIR against me, 5th FIR, I've registered an FIR against them. My lord, I've spoken
We'll
to
give
my
a
learned friend.
quietus to everything. You just give me all the numbers.
My lord,
Kudil.
my lord, if there's a possibility, we'll refer it to mediation, my lord, because if there's a possibility,
There
I've
is-
given him an
I'm
offer
not
as well.
coming in the way of settlement, my
All
lords.
right, now,
I've given him an offer as well.
the parties to the list are in scope, the father-in-law and the daughter-in-law,
Everyone, my lord.
and other
Father-in-law,
members of the
mother-in-law,
family
son-in-law,
are in deep squabble.
sorry, not son-in-law.
All right. The learned counsel appearing for the petitioner and the respondent would in unison submit that if the parties are referred to mediation, possibilities of, they could explore the possibilities of settling the dispute and giving a quietus to all the problems. The learned, therefore, the parties to appear before the Karnataka Mediation Center. Yavat Friday hoಗ್ತೀರಾ? 13th.
Next week.
Friday the 13th, beda. Will.
Next week.
It's not a good day.
It's very ominous. The
Adike Friday the
relationship is bad
13th
to
will
begin
not
with, my
send
lord,
you.
beda.
Yes.
My lords,
Next
the
week, my lord.
20th, my lords.
List on but to appear before the Karnataka Mediation Center on the 20th.
Yes.
List the matter on 25th in the fresh matters list. If nothing comes about, numbers kodi alla, criminal petition numbers alla. Kottiri will tag everything, we'll
Yes.
close it.
Yes, ma'am. Right now, my lords, there are
Enough
only
of
two-
father-in-law
I
and
think, my lord,
daughter-in-law fighting.
20th, my
Yes.
lord, looking at the number of disputes which they have, 20th, it will not happen in one session for sure.
Then
my lord.
no problem. You take your time.
ಅಲ್ಲ,
But
ಯಾಕಂದ್ರೆ
I will give the
20th ನಾನು
date.
report ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ
Report
25th
ಏನ್ ಮಾಡೋದ್ ಬೇಡ.
Please.
ನೀವು ರಿಪೋರ್ಟ್ ಮಾಡಿ ಏನಾಗ್ತಾ ಇದೆ.
Please.
But don't report a next crime being registered.
I'm hoping they won't, my lord. 5 FIRs against us.
Yes, no
Equal,
sixth,
my lords, equally filed by them against.
I
me.
don't have any.
no
JP
sixth
Nagar
from both the
police
sides.
station, my lord, ಏನಾದ್ರೂ ಗೀಚ್ ಇದ್ರೆ they register an FIR for that.
No sixth from both the sides. I'll
I
take
will
it on
before my
25th.
lords, my lord, we're already filing 480 for the other one.
All right, yes.
Please.
They've
Yes.
not yet been filed. We have to file those other two 482s, my lords.
Whatever.
Bagin, better, fire
For one
register
second,
again.
First ನೀವು ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ.
Yes, my lords.
Please, grateful.
Highly grateful. my lord.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order subsisting shall continue to the next date of hearing.
14 and 14.1. Both.
ಯಾವ್ದ್ರಲ್ಲಿದೆ? If any,
ಎರಡು, both.
interim order if any, comma in any shall continue
In
to
all?
the next date of hearing.
Both.
All right,
Please.
yes.
Highly obliged. my lord.
Obliged.
Next, yes. Compounding, POXO. POXO ಅಲ್ಲ ಇದು.
Child marriage.
376.
Child marriage, 76.
Jagdish. Huh?
Senior.
No. At the time of incident, 15, huh?
6.
I will not settle. Don't worry about the child. The state will take care. We will direct the state to take care. We will not settle. ಇದು ಮ್ಯಾರೇಜ್ ಆಗಿರೋದಾ?
Marriage.
ಇನ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಇನ್ಸಿಡೆಂಟ್ ಮುಂಚೆನಾ?
Incident
ಮುಂಚೆ
Child Marriage Act.
ಒಂದ್ ನಿಮಿಷ ಕೊಡಿ ಇಲ್ಲಿ.
The victim herself is the
One
complainant.
moment. Victim herself may be the complainant. You got married first or the incident first?
Got married first.
Who got you married?
Parents.
In this case, you take the parents into, in the sense, we will haul the parents into crime. Henceforth, parents should not register the crime. This should be a lesson to them. They go on getting the children married, notwithstanding the fact that they are less than 18. And madhu admele offense will come about. No, parents should be brought to books in this case. We'll bring the parents. Why are you panting? Parents and
No, I just came
you
down.
came running. Okay, fine.
And there's an inordinate delay of 16 months. She was residing with petition number one.
That's all right. Parents should not indulge in these things. They should stop.
That is-
Huh?
They're also.
They are also accused, true. But they are responsible for getting the children married at an underage and bring them into POCSO. Then religion permits, adu illa. Yes, we'll see. We'll list it on Friday, 13th. Idu judgment is, idu kalsi madam. Yes, next.
16.
Lord, appearing for the petitioner. My Lord, this is that 363 matter. It may be taken up next week. My Lord, we'll report settlement with regard to that. 17 years jail marriage.
Aಯ್ತು ನೋಡ್ ಇದು ಅಷ್ಟೇ ಅಲ್ಲ. List on 20th.
Please.
Yes. Next.
17.
Lord, there was an interim order not to frame charge till then, my Lord.
16. ಮೇಡಮ್ ಯಾವ್ದ್ರಲ್ಲ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಎಂಟ್ರಿ ಮಾಡಿ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೋದು.
Please. Great.
20.
Senior 9.
ಇದು ಅದೇನಾ 20th. Yes.
18.
For petition, my lord.
Senior 10.
After
16
major,
years.
after major, the marriage has been taken care.
So what?
The second FIR also registered, my lord. And they married, my lord.
Look into this judgment of the Supreme Court latest. I cannot settle a single case.
Now she's around 19-year-old.
What to do? Supreme Court, sir. Yes, 20th.
Interim order.
Interim order subsisting shall continue till the next date of hearing.
Serial number 19 to 23 is to be connected with serial number 5.
ಏನ್ ದಿಲೀಪ್ ಇದು?
Same.
POCSO.
ಇದರಲ್ಲಿ 421 ಅಲ್ಲಿ they have issued a NBW. I mean, they are trying to arrest a in FLW.
Why are ಎಷ್ಟಿದೆ?
2 lakhs something ಇದೆ.
In 138 proceeding.
ಹೌದು.
You are the accused.
I am the accused.
The matter was settled, is it?
Matter was settled.
Settled where?
Settled in the court only. The court has acquitted the accused.
On settlement, it is, you are acquitted.
ಹೌದು.
Amal, you did not adhere to the settlement?
I could not make the
You could
complete
not come.
payment.
You are convicted, is it?
It is not convicted, it's
Ah.
acquitted.
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 Acquitted on account of settlement.
ಹೌದು. And then,
Acquittal ಮುಂಚೆ ಏನಾಗಿತ್ತು?
my lord, initially it was the court has,
Proceeding pending ಇತ್ತ, conviction ಆಗಿತ್ತ?
it was economic services.
Conviction ಆಗಿತ್ತು.
Conviction ಆಗಿತ್ತು, we went up to
I
appeal.
will restore conviction now.
No, no,
You
my-
will be taken into custody. If any accused will come before the court and settle the issue and get away with the conviction and later on breach the settlement or terms of the settlement that are arrived at before the court,
It was not intentional.
I will restore conviction in every case. Accused cannot roam around free after having settled the matter and showing that the complainant will get back his money.
I do agree, my lord.
ಎಷ್ಟಿದೆ?
My lord, the different amount, my lord, in each and case. In this case, there is a 4 lakh.
Total ಎಷ್ಟಿದೆ?
Total would be around 58.
Victim comes forward to say that, yes, I will settle, seeing that he will get some money. And immediately after the settlement, you walk away with nothing
There was-
and roam around free. ಎಲ್ಲಿಗೂ ಯಾರ ಕೈಗೂ ಸಿಗಲ್ಲ. I will restore conviction now.
No, the different case, my lord, where the.
Definitely restore conviction in such cases. You get acquitted by a process of law, not by settlement.
Not intentionally, my lord.
Intention was deceit only. Otherwise, you would have adhered to the terms of settlement. Yes, sir. What do you want? ಎಷ್ಟಿದೆ? Total ಎಷ್ಟಿದೆ?
Total would be around 60 lakh.
16.
60.
60. ಈಗ 30 lakhs deposit ಮಾಡ್ತೀರಾ?
We have
Stay
already
ಮಾಡ್ತೀರಾ?
deposited 20%, my lord,
Where?
in the lower court.
That is 148A proceedings. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಅದಾದ್ಮೇಲೆ settlement ಆಗಿರೋದು.
ಇಲ್ಲ, ಇಲ್ಲ.
And settlement, sir, settlement ಆಗಕ್ಕೆ condition precedent is that 20% should be deposited, so you have deposited. There cannot be a settlement without 20% being deposited.
No, before that only the matter was settled.
No problem.
Even before
ಈಗ
conviction, the
ಆಯ್ತು,
matter was settled.
another 30%.
But-
I will state only if you deposit 30% on the rest, 50 is 30, 20 lakhs.
ಮಾಡ್ತೀನಿ, but reasonable time may be.
No, sir, you're an accused who has breached the settlement and is walking free. And in victim settle ಮಾಡೋದಲ್ದೆ,
Right.
go before the executing courts, go roam around for getting the matter executed, the decree executed.
It's a project, my
ಆಯ್ತು,
lord.
FLW, sir.
It's a project, my lord, where the house they have wanted to buy, And then, Your Honor, there is a dispute between the landlord and the,
ಏನಾರು ಇರ್ಲಿ, you have settled the dispute, you better obey the settlement. Otherwise, I'm going to restore conviction.
30% reasonable time.
20%. List the matter on 27th September in the fresh matters list.
For 4
There
weeks,
shall be,
4 weeks.
there shall be an interim order of stay of any kind of warrant hanging on the head of the petitioner, subject to the condition that he would deposit 20 lakhs of the amount by the next date of hearing. List on 30th anta ಮಾಡಿ. 30th in the fresh matters list.
30% at the amount.
ಬೇಡ, 20 lakhs. Yes. All, tag all these petitions, madam.
But the serial number 5 is connected with all these matters.
5
Oh,
5 ಜೊತೆಗೆ, ಶೋಧ madam. 5 ಜೊತೆಗೆ
19 to
19,
23.
20, 21, 22, 23, all together. Yes. Next.
24.
Petitioner, my lord.
Along with council submission,
I filed joint memo.
settlement,
Yes.
offense,
Folks,
also,
marriage,
marriage,
marriage was done.
Age?
Registered at the time of incident, 17 years, 7 months. There,
17/7. Then day after tomorrow. Yes. Don't get the parties until I tell you, madam. In POCSO cases, please don't get the parties. Only if I tell that there can be a settlement, then get the parties. Please, day after tomorrow. Yes.
25.
appearing for petitioner, my lordship.
ಅವ್ರು ಆ ಕೇಸ್ ಅಲ್ಲ, ಏಜ್ ಪ್ರೂಫ್ ಇಲ್ವಾ?
Birth certificate.
My lordship, she's turned 18 years, my lordship.
Where is the birth certificate? ಇದು ಪೊಕ್ಸೋನಾ?
Aadhaar card is filed, my lordship.
ಆಧಾರ್ ಕಾರ್ಡ್ ಬೇರೆ ಏನಾದ್ರು ಕೊಡಿ. ಇದು don't get the parties till I tell you. List day after tomorrow.
My lordship, latest order sheet, my lordship.
ಕೊಡಿ. Yes. Counsel with the petitioner files the complete order sheet maintained before the court. Same is taken on record. Next. Day after tomorrow.
Obligement.
Madam, separate list ಮಾಡ್ಬಿಡಿ ಪೊಕ್ಸೋದೆಲ್ಲ. Day after tomorrow.
Mapping for petitioner is,
ನಾಡಿದ್ದು ಅದಕ್ಕೆ ನಾಡಿದ್ದು ಆಗ್ತಾ ಇದೆ.
mapping for petitioner is case ಮಾಡೋದು.
ಹಾ?
Petitioner is case ಮಾಡೋದು.
ಇದು day after tomorrow. ಜಗದೀಶ್ separate list ಮಾಡಿಸ್ತಾ ಇದ್ದೀನಿ. You get ready in all those cases. Yes, next.
27.
For second respondent, SPP may be directed to take notice. He is a medical officer.
Age proof of the victim, my lord, is
ನಿಮ್ದು ಪೊಕ್ಸೋನಾ?
Child marriage and folks.
ಆಯ್ತು.
age.
My lord, 18
Age
years
proof ಎಲ್ಲ ಕೊಟ್ಟು day after tomorrow will take. Learned additional SPP is directed to accept notice for the second respondent petitioner to produce the proof of age of the victim by the next date, day after tomorrow. Next.
28.
For petitioner.
ಇದು ಅದೇನಾ?
11.
For petitioner, 311 application reject ಆಗಿದೆ sir.
Office objection ಏನು?
Petitioner number 2 and 4, name wrongly mentioned some names.
311 application rejection. Will dispose it tomorrow.
TW
List tomorrow in the fresh matters list.
ಸ್ವಾಮಿ 13/9 ಡೇಟ್ ಇದೆ ಸರ್.
13?
9 ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ.
13/9. ನಾಳೆ ಏನು? 10 ಅಲ್ವಾ? 13ಕ್ಕೆ ಮುಂಚೆ ತಾನೆ? ಆಯ್ತು, ನಾಳೆ. ಎಸ್.
29.
By special order. Why?
Yes, last time it was.
Bail matter. Yes.
Bail, 324,
Not seven.
307, 506.
ಕೊಡಿ. Tomorrow in the fresh matters list, give the records. One more day. Tomorrow.
5 months in the. ಒಳಗೆ.
Tomorrow. Yes. Records ಕೊಡಿ.
30.
Vacating interim order.
Petitioner, my lord.
Today it has to be heard under today, it's not possible.
My lord,
Not to.
is a case of accidental fall, my lord. They have given a color of 302 it is. My lord, a FIR, my lord, was registered as an UDR initially. Let me hear the facts, my lord. My lord, it is a death of wife, my lord. my lord, wife, husband and 2 children, my lord, they were residing, my lord, in an apartment which is located, my lord, at 16th floor in Golden Garden apartment at Yeshwanthpur. My lord, on the day of festival, my lord, they had prepared some special food. My lord, this lady went to keep, my lord, in the ladder, my lord, this that utensil. She slipped, my lord, and fallen from 16th floor to down. My lord, she sustained multiple injuries and died. My lord, everyone lodged a complaint, my lord, it is a case of accidental fall. The respondent number 4 here, my lord, who is the son, himself is the complainant. He wrote complaint in his handwriting, reported to the police that my mother died because of accidental fall. My lord, the police registered UTR. My lord, after UDR, my lord, the body was shifted to mortuary. Next day, my lord, body was preserved till the arrival of all the blood relatives. My lord, neighbors were all secured. The police investigated. My lord, the apparent cause of death during inquest was, it was an accident fall. Maybe by slip, the deceased might have fallen from 16th floor. My lord, this was consistent by virtue of even autopsy report conducted. Now, my lord, that after this was over, my lord, the corpus was given, they performed funeral, my lord. After 15 days, my lord, the parties, my lord, they are from Punjab. They went to Punjab, my lord, to put this hasti in some river and all that. They returned back after 15 days, my lord, with the story that she committed suicide. They lodged a written complaint, my lord, that my mother committed suicide, and therefore the FIR, my lord, for 306 only registered.
Then when did 302 come?
302 comes in the charge sheet, my lord. Your lordship may kindly see, after 15 days, the FIR was for 306. My lord, investigation was taken up for 306. My lord, the accused was arrested immediately on 11/9. My lord, he was there in custody. After 15 days, he was granted bail. Once the father was granted bail, my lord, the son, my lord, he got annoyed. My lord, at the instigation of maternal uncle, my lord, one more petition was given. And my lord, they went to magistrate and gave a statement under 164 stating that it is not a case of neither suicide nor accidental fall. It may be a case of murder. My lord, now this, from this stage onwards, my lord, after 164 statement, investigation, my lord, was continued for 302. My lord, no legal material could be collected. Lordship may kindly see, neither there is a medical evidence to show that it is a case of homicidal death, nor any person deposed evidence that they saw that this accused committed any act which could constitute offense of homicidal act. My lord, in the absence of it, my lord, that they filed a charge sheet, my lord. In the meanwhile, my lord, what happened was, a pressure was that the investigation officer to be changed. Now, my lord, that a petition was given to commissioner. Commissioner, my lord, that he did not pass any order. The DCP, he passed one letter, my lord, stating that let the investigation officer be changed. My lord, originally the matter was before RMC police station inspector. He issued a letter, my lord, stating that Bagalgunta police inspector may take over this investigation, investigate the matter. From that stage onwards also, my lord, he could not collect any material with regard to the overtime that was committed by this accused, which should constitute
Charge
offense
sheet
of
is
302.
filed by which investigating
My
officer?
lord, Bagalgunta police, my lord, that police inspector. Here one point of law, your lordship may kindly consider. My lord, the transfer order which was given by DCP, my lord, from RMC police inspector to police inspector of Bagalgunta police station. My lord, but the charge sheet is filed for the same crime number of RMC police station, for which, my lord, Bagalgunta police station officer, my lord, was not the officer in charge of the police station.
Then it
My lord,
requires.
this is the point, my lord, that
requires detailed hearing.
yes, it requires, my lord, that we permitted to file that letter, my lord, we could not.
Whatever you want, you file. I'll fix a
produce,
date.
my lord. My lord, interim order is there, my lordship,
We'll
kindly
hear,
extend
we'll
it.
hear it. Yes, Manu, you also file the entire list of dates and judgments or whatever you want to file.
Discharge application.
Discharge hakidara.
Discharge have been dismissed, that is what they've been charged.
My lord, we filed an application for
Whatever,
discharge
yes.
against that, my lord.
List the matter on 18th, 19th at 4 p.m.
Lordship, may kindly on 24th, lordship.
Why?
My lord, the division bench it is posted, my lord, matter is there.
19th.
Yes, 17th, 18th, 19th.
All right, then 24th. List on 24th at 3:30 p.m. for further hearing. You file whatever is to be filed? Yes. In advance, if you file, I will go through and come. Yes.
I also have to
Yes,
file an
ನೀವು ಅಷ್ಟೇ
application.
ಏನೇನ್ ಬೇಕೆಲ್ಲ ಹಾಕ್ಬಿಡಿ.
Yes, you.
Yes. List, so and so, interim protection slash order, if any, subsisting today shall continue till the next date of hearing. Yes, Vinod Kumar,
My lord,
post
420
immediately after service of notice upon the second respondent, interim order there.
ಇದೆ.
Interim order subsisting shall continue till the next date of hearing. Same order, 32.
My lord, one submission,
Yeah.
serial number 7, my lord, could not be present, my lord. Interim order may be extended.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number
ನೀವು
7.
ಇಲ್ಲದೆ ಇದ್ರೆ interim order extend ಮಾಡಿರ್ತೀವಿ sir. Yes.
Much obliged.
32.
Office objections.
Plus, it's compliant. Only two objections, my lord, we have.
Only two.
Alla,
That
ಅದ್ರಲ್ಲಿ
also objection ಏನು?
One is that, my lord, the page.
Accepting
horizontal-
submission of the counsel for the petitioner, office objection stand overruled. List day after tomorrow in the fresh matters list. Next,
Grateful.
33.
PF, Rakshit,
My lord, respondent number 2 is none other than state itself, my lord.
none other than state. Yes, Leonard
This is,
HCGP is directed to accept notice for the respondent. Second respondent as well, register to print the name of the additional SPP as appearing for the second respondent. Sorry, HCGP as appearing for the second respondent. Interim order ಇದೆಯಾ?
No, my lord. My
Yes.
lord, this is a matter where JJ board did.
ಅದೇ JJ board documents ಕೊಟ್ಟಿಲ್ಲ.
Yes, my lord, yes.
We have to lay down some, we'll see. ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಆಗೋಯ್ತು. List the matter on 18th. R2?
R3 ಬೇರೆ ಇದೆ.
R2 state ಅಂದ್ರೆ?
R3 ಬೇರೆ ಇದೆ. R1 and
R2 is not state, sir. A 2 weeks time is granted to take steps que R2. Yes.
Please, my lord.
ಬೇರೇನು ಬರಿಬೇಡಿ ಮಾಡಿ. ಅಷ್ಟು ಸಾಕು. Yes, next.
Hearing on IA 34.
My lord, I'm appearing for the petitioner.
ಹೋಗ್ಸೋಣ.
Illa, sir, 498A.
ಆಯ್ತು,
Matter is settled in BMC, divorce has been granted.
ಆಯ್ತು ಕೊಡಿ.
I've also
Yes.
filed the joint
Page,
memo of
page.
settlement.
Page.
Lord, and the IA for compounding, page number 15 is the joint memo reporting settlement.
ಎಲ್ಲಿದೆ?
I filed an IA under 322.
ಎಲ್ಲಿ? Madam, settlement. Yes.
Page number 15 is the memo reporting settlement. In this, R2 has signed the memo. I have also filed the BMC settlement and the judgment of the
The
family.
petitioners are before this court calling in question so and so. Parties are there?
All 5 petitioners
Yes,
are
the
here.
petitioners are before this court calling in question proceedings in so and so other prayer lakpadi. The parties were before, the husband and the wife were before the family court in MC 2394 of 2020, where they have settled the dispute amongst themselves by drawing up certain terms of settlement. A term of settlement would,
Point number 11.
term of settlement also recognizes the closure of these proceedings. The respondent ilva? Respondent is
She's
here.
served, she's not engaged her advocate in the
But
first matter.
where is the respondent?
Respondent is not present.
What is this? How can I settle it?
Her advocate is present for the second matter. She-
Where is the advocate?
He was here. He was
Pass
here.
over, wait. If he comes, tell me. Yes, pass over, sorry. Next.
Admission 35.
For the complainant in this.
35.
Charges have already been framed, my lords. Charge sheet ಎಲ್ಲ ಹಾಕೈತೆ, charges
ಅಲ್ಲ,
ಎಲ್ಲ
before or after?
No,
Then
after the filing of the petition. Stay ಏನಿಲ್ಲ.
stay ಇದೆ ಅಲ್ವಾ?
Stay ಇಲ್ಲ, stay ಇಲ್ಲ.
ಇಲ್ಲ, ಹಾಗಾದ್ರೆ ಹೋಗ್ಲಿ ಅಲ್ಲ.
no. Your lordship, it just perused the order sheet.
Uh.
That the time was taken by the state for perusal
No,
of the.
I am not on that ground. Come on merits.
Correct, my lord. Because the complaint is saying that there is a transaction between the complainant and the accused regarding finances concern. That he admits that 40 lakh rupees, he's taken loan from me. And then it is his contention that he's repaid the entire amount at the cost of 15% of the.
I
of the-
will, if that matter is over, I'll take up these admission matters or fix a date. Yes, Advocate General is come, Learned Advocate General. I'll start.
Could your lordship put on the 18th, my lords, 18th.
ಎಲ್ಲ all on 18th, if the matter doesn't get over. ಇದು list on 18th ಅಂತ ಹಾಕಿರಿ. I'll let you.
Lordship, meantime, there's an interim order is passed.
Interim order ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ.
ಇಲ್ಲ, ಅದು.
2 years ಇಂದ ಇಲ್ಲ. 18th will take.
Only the order was that his presence will not be precipitated.
That will continue.
That should be continued.
Whatever protection orders are pending, just continue them. Yes.
number 4,
Wait, I'll finish that and come back. You're in a hurry.
But serial number 52,
No, if I take one, then I'll have to call the
Yeah.
entire list.
no, it may be accommodated tomorrow.
ಮತ್ತೆ ಅದನ್ನ ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Wait, sir. Yes. ನಿಮ್ದು ಯಾವ್ದು? Wait, I'll just finish this and get back. ಎಷ್ಟಿದೆ ಮೇಡಮ್? ನಿಮ್ದು ಏನಿದೆಯಾ? Wait, yes.
Please,
It will take an hour?
please. I'll
1
take
hour.
your 1 hour.
Ah, yes. So others can come back at 4:30. Madam, ನೀವು ಹೊರಡಿ.
Please, Manoj, only on the point of law, Manoj, I'll not go into the facts as it is, Manoj. Only 2-3 aspects, Manoj, which your lordships have already dealt with. I just want to, the judgments which your lordships have mainly dealt with, Manoj, is the prior
I have not dealt with it. Oh, Ashok.
Ashok
All
and
right.
Pradeep Kumar and Shri Rupa, all those judgments, Manoj, what your lordships have dealt with is where a case prior, cases where, Manoj, prior approval has been granted under 17A by the competent authority, Manoj, which were questioned before your lordships. This is a case, Manoj, slightly on the lines of Dr. Ashok, Manoj, where a private person, Manoj, seeks permission, prior approval under 17A. So therefore, Manoj, the distinguishing feature is, Manoj, where prior approval is sought by a police officer and which has been granted as against a private person seeking a prior approval, Manoj. So just, your lordship may kindly see section 17A for a moment, Manoj. It says that no police officer shall conduct any inquiry or investigation to any offense alleged to have been committed by a public servant under this act, then, Manoj, where the alleged offense is relatable to any recommendation made or decision made by him, taken by him, by such public servant in discharge of his official functions or duties with the previous approval. Then, Manoj, second proviso is important, Manoj. Provided further that the concerned authority shall convey its decision under this section within a period of 3 months. So therefore, Manoj, the condition precedent for this is, Manoj, there should be a preliminary inquiry done by an investigating officer, Manoj, which has to be placed before, given along 17A, Manoj. The reason is this. When,
So,
Please.
to get clarification, sorry. Now, are you suggesting that prior to 17A approval being granted, there should be a preliminary inquiry?
as held by Lalit Kumari, that is what the your lordship is saying.
Then you are equating 17A order to an FIR.
No, that is why your
If,
lordship is.
if you're equating 17A order to an FIR, preliminary inquiry is necessary.
Therefore,
Otherwise, yes.
Therefore, my lord, if your lordship sees if your lordship sees, my lord, Lalit Kumari clearly says, my lord, in so far as cases of corruption cases,
True, para 120.1.
one and
6 postulates there.
6
Yes.
postulates, we come in clause D, C and E, my lord.
Yes.
If we come under clause C and E of Lalit Kumari, my lords, it is mandatory that a preliminary inquiry is done. I'm not talking about inquiry as contemplated under 17A. What I'm saying is pre-17A. Your lordship may kindly see pre-17A is a mandatory requirement.
Pre-17A, all the 3 circumstances, inquiry, or investigation.
I'll be able.
For all the 3, you need 17A approval.
Correct.
Where is the question of the 17A, prior inquiry under 17A without compliance with 17A?
So, your lordship may, I'll take Lalit Kumar, your lordship may kindly see.
Please take para 120.6,
Please,
2014,
your lordship may
21,
kindly
page 1, yes.
This court, written submission, I've just culled out the relevant paragraphs.
Ah.
Photos.
ಅದು ಓದಿ ಹೇಳಿ ತೊಂದ್ರೆ ಇಲ್ಲ. 14(2) SCC page 1, para 120
Your
ಹೋಗಿ.
Lordship may kindly turn to page 61, my lord,
Hmm.
of my. At page 62, 61 it starts. my lord.
You know the list of other written.
No, just a notes, instead of going to all the judgments, my lord, whichever judgment I'm relying upon, I've called out the relevant paragraphs, my lord.
All right.
As the Lordship pointed out, my lord, that 120.6 D and E, my lord.
Hmm.
120.6, as to what type and which cases preliminary inquiry is to be conducted will depend upon the facts and circumstances of each case. The category of cases in which preliminary inquiry may be made are as under.
ಅದೇ
So,
D and D.
D and D, where the case is abnormal delay in latches. This is a case of 22 years, more than 20 years, my lords. 1998, according to them, my lords, is a case of denotification, assuming for,
So you're,
no, I'm saying
you're
it is a case
you're
where,
thinking to that. Yes.
please,
Where there is abnormal delay.
abnormal delay. So
Then
there,
you may be just.
please, so,
All right, yes.
so therefore, my lords, coming under the corruption case and under abnormal delay, my lords. The question is preliminary inquiry is mandatory. So therefore, my lords, that is why, my lord, the language used, first portion, no police official shall conduct any inquiry or investigation, so and so, so and so, and so, as committed by a public. If your lordship read the SOP, my lord, which will give further more clarity. Your lordship may kindly take volume 1.
Page 703.
Please, 6, please, my lord.
706, yes.
That's the crux of the whole thing, my lords.
Volume 2, 706.
Absolutely, my lords.
Yes.
Annexure M, my lords.
Yes, sir. SOP of the Government of India on 17A.
Please, my lords.
Yes, sir.
So the private person cannot be put in a higher pedestal than a police officer, my lords. What, assuming, my lords, the preliminary inquiry has to be done. This is what the crux of the whole 704, my lords. So as to standardize and operationalize procedure with a view of achieving uniform and effective implementation for prior approval, processing under 17A of the Act, the set of SOPs are hereby conveyed. First stage processing of information received by the police officer. In this case, my lords, this has not been done. Then, my lord, 705, what as your lordships were pointing out, standard operating procedure for handling information in respect of a public servant alleging offense under the PC Act, seeking of previous approval for conduct of inquiry or investigation under section 17A. Then, my lords, clause 2, it may be emphasized that the provisions of section 17A stipulates a mandatory requirement for a police officer to seek previous approval for conducting so and so, so and so, so and so, alleged to have been conducted. The police officer upon, this is the requirement, 3.2.
No, that would bear reference only to a crime registered before a police officer. No, that would not cover private complaints. Private complaints was a concept that was evolved by this court in GV Ashok, so that SOP won't help.
No, it will help. The reason is it is a case of private complaint before the police officer.
Where?
Here is a, not sorry,
complaint
private, a complaint registered before a police officer. That I'll come to 154, 173, 1 and 4 much later, my lord. Here is a case where a complaint is given to a police officer, sufficient time is not given. They jump the gun and apply for 17A in compliance of your lordship judgment in Dr. Ashok's case.
Where is jumping of the gun here?
Because, my lord, I'll come to the facts with regard to 150. Why preliminary inquiry, what is stipulated, that is 15 days to 6 weeks. They don't wait for that. Then they apply for 17A for compliance of Dr. Ashok's case. So therefore, my lords, what has to be read is the preliminary inquiry. Ultimately, my lords, the governor does not do the preliminary inquiry. He only grants prior approval. In this case, what has happened, my lords? He sits as the preliminary, does the preliminary inquiry. That is hearing the complainant for 1.5 hours, according to them.
All right.
Then issuing show cause notice, seeking clarifications, seeking reply. So therefore, my lord, that is the sole jurisdiction of the police officer as per the SOP and as well as the judgment of this.
And even as per 17.
As per. I'm born into. I'll just point out, highlight a few aspects in this SOP, your lordships have read, my lord, just to.
Sir, you can.
Then clause 4, my lord, page 705, 3.1, Roman 4. Roman 3, specific acts of commission or omission attributable to such public servant. This, whether such acts are relatable to the official functions or duty by the such public servant, specific to the office post held at the time of commission of the alleged offense, specific recommendation or decision taken by the, my lord, all these aspects are very crucial because this says when the police officer or the investigating officer seeks for sanction, these requirements has to be placed before the competent authority. Then, my lord, page 706, that Roman 4, the proposal of the police officer of the appropriate shall contain the following information. So therefore, my lord, the proposal is the formation of an opinion by him prima facie that cognizance of this case has to be taken. 4.4, the appropriate officer of the appropriate rank shall make a proposal of the to the appropriate government, as such case may be through a single window process as laid down by these SOPs, and shall ensure that the proposal is in accordance with the requirement laid down in the checklist, enclosures, clear, legible and authenticated documents as may be required. Separate proposal shall be submitted for, this is important, what your lordship just said. Separate proposal shall be submitted for inquiry or investigation as the case may be. Your lordship may now kindly see the page 707, my lords. What it says, the incomplete proposal should be sent back by the competent authority back to the investigating officer. Then so therefore, what is the approval which speaks previous approval is the proposal sent by the investigating officer. In this case, my lords, or if I'm giving a hypothetical, tomorrow all citizens or any busybody gives complaints against everybody, my lords.
That's precisely why I wrote prior approval is needed.
Dr. Ashok has said, because it first compliance of 154, prior approval, then comes the complaint. Here, my lords, what has happened, as I said, 154, here, my lord, even what is applicable to a police officer, the same procedure ought to have been applied, the competent authority.
Followed by the governor?
No, governor ought to have asked the private party to say that, give the information with regard, there are two aspects, my lord.
So much of information is given.
No, with regard to the format, allegations have been given. My lord, there are two aspects, my lord. One is formulation of an opinion can be done only by the investigating officer, not by a private party. His opinion will not make any difference. So therefore, there are two stages. One is you ought to have given as per the requirement of law. Once having received it, my lords, the competent authority does not does not do the preliminary inquiry. It is the competent authority could have asked, as required under law, the investigating officer to give the information. He ought not to have sat as an inquiry officer, investigating officer. In fact, your lordship, what is page, if your lordship see page 709, the checklist goes to show, my lords, when prior approval is given, the competent authority has the benefit of all the material and data which is required under 17A. Can I read the page 79, the checklist, my lord? First is name and designation of the office held by the public servant. Then post or office held by the public servant at the time of the alleged commission. Then whether the request is based on a complaint received, if yes, copy of the same. Whether the complaint prima facie reveals deriving of an undue advantage by a public servant, whether any information is available in respect of bribe given, then please provide specific details of recommendation made or decision taken by the public servant, which is relatable to the offense alleged against the public servant. In case of preliminary inquiry was undertaken at the early stage, please enclose, my lord. Then whether any criminal offense. So therefore, my lord, this is what is approved under 17A, which goes to show that there is an application preliminary inquiry done, there is a proposal, there is a report, and application of mind is to this. Therefore, my lords, my submission is on point of law is, my lords, is that the allegation or the complaint which was sought for under 17A ought to have been returned. Second aspect is, my lords, if it was accepted, preliminary inquiry information, instead of asking the complainant or the show cause not having issued to the petitioner, it is information ought to have sought for from the investigating officer in terms of 17A or the SOP issued by the central government. That's my first submission. Therefore, my lords, I'm not going into as to the rest of the process. The main thing is you ought not to have entertained the application itself, my lords. As your lordship initially pointed out, my lords, 17A does not contemplate preliminary inquiry. I bow down to that. What is requirement of Lalit Kumari and your lordship's line of judgment, my lord, that preliminary inquiry is mandatory, is what ought to have been followed. Your lordship may just. The next aspect is, my lord, insofar as recommendation is concerned, next is the heart of the whole thing is, my lord, is whether there is any recommendation or decision made. My lord, it applies both ways. What ultimately the argument will say, I don't need the protection because I'm not in any other case, if 17A application, if the protection, if we are seeking saying that it does not come within the 17A, the protection under 17A goes. Here,
If you do not offense under the PC Act illa andre.
PC Act, that is under.
All right.
So therefore, my lord, what is crucial, my lord, is that offense has to be relatable to decision, recommendation, and the office head. The lordship may kindly see 2-3 judgments on those lines, my lord. I just reproduced it in my compilation. I just would like to take your lordship to the relevant paragraph, my lords. Your lordship may kindly turn to page 27, my lords.
Yes.
This is Nara Chandra Babu Naidu versus State of AP, my lord, 2024 SEC online. I'll just read para 3 just above that, my lord. In this context, the current case, these definitions underscore the importance of establishing a clear connection between alleged corrupt act and the official recommendation or decision linking the same with the public servant. This interpretation reinforces the protective intent of Section 17A, ensuring that the public servants are shielded from unwarranted investigation from acts not directly connected to their official duty. Para 55, in para 4, Section 17A has the following 4 more facets. Inquiry or investigation of the offense under PC Act. Alleged offense should be related to the recommendation made or decision taken by a public servant. Such recommendation made or decision taken by the public servant should be in discharge of his official functions or duties, and the previous approval of the authorities mentioned therein. My lord, in fact, in B.S. Yedurappa's case, my lord, case of denotification, the division bench of this court, my lord, in para 31, I've just quoted that as said, even otherwise, the order of denotification passed by the petitioner, in this case, it's not passed by the petitioner, para page 31, in the circumstances discussed above, cannot be construed as any recommendation made or decision taken by the petitioner in discharge of his official duty so as to attract Section 17A of the PC Act. So, my lords,
yes,
this is, and next, my lords, even the Gujarat High Court also has held on identical. The word relatable is an adjective. The legislature in its wisdom has used the adjective relatable to connect the offense to a recommendation made or decision made. Therefore, such approval shall be required when the offense is associated with and connected to a decision taken or recommendation made by a public servant in discharge of his official duty or function. use of the adjective relatable to the offense is considered opinion of this court, limits and restricts the offense to be associated with and connected to a decision taken or a recommendation made by the public servant in discharge of the official duty or function, and therefore can't be extended to all offenses under the PC Act. The same is Madhya Pradesh High Court, para 6.3. Section 17A is attracted only when the offense alleged under Section PC Act relates to the act of recommendation made or decision made, but is not attracted when the offense relates to demand or acceptance of bribe, taking to an illegal gratification or disproportionate.
No, that's why trap cases gate is not applicable.
Please, my lord. Then last is Kerala High Court judgment, my lord. Ultimately, my lord, that is why the SOP becomes very, very important, my lord. The checklist gives for the purpose of formation opinion, para 9. The most crucial part of section 17A provides that the previous approval is required in relation to an inquiry or investigation into an offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable to any recommendation made or decision taken by the public servant. It seems that the above part of the section is most crucial part of the section, since imposes a rider that otherwise the absolute power under section 17A, so and so, so and so, and so and so, in every act needed prior approval.
Yes.
Well, next one other aspect, now, if your lordships kindly turn to page number 13, my lords. This is with regard to H1 Sinha versus CBI, with regard to preliminary inquiry, my lord. Just going back.
3.
Page 13, my lords.
Yes. Sirajuddin is followed.
Sirajuddin is followed, Yashwant Sinha and Prabhat Kumar Dubey, my lords. The reason I'm using the preliminary inquiry, my lords, preliminary inquiry has to be, so even in case of Shrirupa, my lords, what the courts have said that while doing the investigation officer should have credible evidence based on which an opinion is formed by him for the purpose of seeking of prior approval under 17A.
Yes.
So therefore, my lords, in this case, my lords, I mean.
According to you, the petitioner has not done anything that is relatable to a decision taken or a recommendation made.
I'll slightly modify it. What is not there in this is, my lords, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please, my lord.
According to you, the petitioner has not done anything that is relatable to it. Sir, petition, you're appearing for the complainant?
No, your lordships are saying petitioner
No.
is accused.
Petitioner is accused. That is what I'm saying. According to you, you are for the government, right?
Please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that. That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lords. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is even for an application seeking prior approval under 17A, there should be a preliminary inquiry as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry and the competent authority himself has now acted instead of referring it to the police for preliminary inquiry as an approving authority conducting inquiry himself and passing an order. That is your submission.
Second submission. And the third is, my lord, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the three requirements, my lord. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third most important, in discharge of his official.
Correct. That is there. That is the soul of the, see, that is the soul of 17A. In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordship has said, what is the object and purpose also of 17A is to protect the thing. And why it should not be abused also, your lordships have dealt been Dr. Ashok and Pradeep Kumar,
All-
in all those cases.
All right.
Keeping those in mind, my lord, the question, what your lordship's question, your lordship will decide is, my lords, not only in this case, any other, I mean, on a principle of law, my lords, a trigger-happy complaints are filed day in and day out against various public servant to the competent authority, my lords. Then the nature of inquiry, again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, my lord, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, my lord. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only an police person, my lord.
Oh, you're coming at that.
I've been trying to come at that. my lord.
Yes. All right, yes.
So therefore, my lords, ultimately, unless that report is there, that is what, I mean, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, there may be, ultimately, my lords, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
Report of the investigator.
investigating, he independently, he gives approval to, therefore, my lords,
Approval for what if there is already a report by the investigating officer?
no, therefore, he may accept it or reject it.
No, approval granting, in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, my lords. So therefore, my lord, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offense which he formed, the investigating officer forms in view of the bar under 17A. He has to seek permission from the competent authority and the competent appropriate gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumar's principles.
Principle. Then, my lord, your lordship, the lordship circular also may be kindly seen, my lord.
Lordship circular, High Court circular.
Your pursuant to your lordship's
Order,
pursuant to your
Ashok, yes.
lordship judgment in
Page-
Dr.
Page, Dr.
Ashok's-
V. Ashok or something, yes.
Please, my lord.
Page,
That is-
sir.
That is at page number, my lord, volume 1.
Citation, madam, volume 1.
Page 260.
260.
In fact, my lord, what you're keeping in mind, the object of 17A, my lords, what your lordship said. is
60.
260, volume 1.
1 second, sir. Of the
Petitioner's paper.
Petitioner's volume.
petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page number, but I need not.
No, ಯಾವ volume ಅಂತ ಹೇಳಿದ್ರೆ volume also I should know. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
That's why.
easy to remember.
ಹಾಗಂತ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Shivasa, my lord.
And Yashwant Sinha later.
Please, my lord.
Yes.
That is affidavit 173-1 and 173-4. I'll come to that, my lord. Here, page 261, my lord. The language, what your lordships has said at page 261 is, my lord. Even if not to entertain such complaint if they do not comply with the following. That is, my lords, one is registration of the complaint, then prior approval in case of a prior complaint. Then last paragraph, my lord, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave as an exception, such complaint shall bear the scrutiny so and so. So therefore, my lord, pre-requirement is compliance of 154 or 173, then 17A. So therefore, my lord, again, my lord, here comes back to Lalit Kumari once again, my lord, because it has, there is no application of mind or not application of mind, no preliminary inquiry, I put it, the language used by the Supreme Court, my lord, no preliminary inquiry done in this matter, my lord. And coming back to insofar as 154 and 173, your lordship may kindly see on the 3 volumes were given by the counsel for the governor, the Solicitor General, my lord. If your lordship sees, my lord, on those volumes, there is no complaint is given